Journal of Christian Reconstruction, Disaster by Decree, the Supreme Court Decisions on Race and the Schools, Lino A. Graglia, Ithaca, Cornell University Press, 1976. Reviewed by Tom W. Rogers. An understanding of the nature of constitutional law has to be derived from the court's actual performance in specific areas of constitutional law. No other area so well illustrates the fact that the Constitution is what the judges wish to say it is. The 1954 Supreme Court decision of Brown v. Board of Education of Topeka gave impetus to a revolution in race relations that was already gaining noticeable momentum, with dire warnings of future success. Of even greater importance was the fact that a decision of such consequence could be made and be made to prevail by our least accountable and least representative institution of government. The result was a drastic change in the perception, both inside and outside the court, of the court's role and power in the American system of government. The court was to increasingly become a tempting, willing, and seemingly omnipotent instrument for effecting fundamental changes without obtaining the consent of the American people or their elected representatives. It has become the most important institution of American government. The Brown decision, as announced, meant simply the prohibition of racial discrimination by government officials. The alleged basis was the 14th Amendment adopted by legislative bodies of both the central government legislature for District of Columbia schools, as well as a number of state legislators, which enacted the amendment, which the court in 1954 claimed prohibited segregated schools. Subsequently, the court moved from a decision which Graglia feels could be understood and justified, unquote, to a compulsory integration, which has meant, quote, that the use of racial discrimination by government officials was not only permitted, but for the first time in our history was constitutionally required. The court's strategy has been to claim one thing while requiring another. By this strategic coup, the court released itself from a need to justify compulsory integration on any alleged constitutional or other merits, and helped minimize any potential national concern by seemingly confining the applicability of the requirement to the South. However, each succeeding decision made clear that the court's declaration of requiring the elimination of segregation was, in practice, superseded by requirements of racial discrimination in order to promote integration. The increasing gap between what the court was doing in fact and what it was required to say is that it was doing in order to maintain its desegregation or remedy justification for compulsory integration caused it increasingly to resort to methods of decision-making so unprincipled and unscrupulous, so heedless of both fact and reason, and disrespectful of federal statutory law, the 1964 Civil Rights Act, that they would not be tolerated by the American people if practiced by even the validly political institutions of American government. Even if compulsory school or racial integration could somehow be defended, the performance of the court in imposing it could not. If, as is often asserted, the court's extraordinary power in America ultimately rests on a moral foundation, its power to compel school racial integration rests ultimately on nothing. In 1896, in Plessy v. Ferguson, the court upheld Louisiana's statute which provided equal but separate accommodations for the white and colored races in passenger trains. In accordance with judicial tradition, the court in Brown made an appearance of continuity while effecting a complete reversal of direction. In Brown, the court stated, quote, whatever may have been the extent of the psychological knowledge at the time of Plessy v. Ferguson, unquote, the Brown reversal of the principle was allegedly amply supported by modern authority. As many commentators quickly pointed out, both those supporting and opposing the decision, the finding that school segregation had adverse educational effects on Negroes was not amply supported, if supported at all, by scientific knowledge. In addition to opening itself to the contention that the decision was social science rather than law, and fallacious social science at that, the court clearly left itself off in further consideration of a decision on the basis of new evidence. No further consideration of evidence was to be allowed, as illustrated in the court's reversal of Stell v. Savannah, Chatham City Board of Education, 1963, Strong v. Board of Education, 1964, stated, insofar as the opinions of experts in the fields of psychology and anthropology may constitute an attack upon the major premise, separate educational facilities are inherently unequal. They are rejected offhand. So much for moral credibility. If justification of the Brown decision depended on the court's explanation of why segregated schools are necessarily unequal, its decision based on the evidence which has become available since Brown would still be without justification. That the Brown decision did not in fact turn on its alleged finding of educational harm from segregated schools was apparent in Bowling v. Sharp, which involved the District of Columbia and was decided on the same day as Brown. The Equal Protection Clause of the 14th Amendment was not available in bowling, since its restriction applies only to the states and not the federal government. Because constitutional provisions have little to do with constitutional law, however, this presented no difficulty. School segregation in the district was accordingly found to violate the Due Process Clause of the Fifth Amendment. The court had purportedly distinguished Brown from Plessy rather than overturning it. However, in Bowen decided on the same day, it simply pronounced racial discrimination as a feature of the Constitution. Plessy, the court had said, dealt with transportation, not education. Within a week, the court was reversing and remanding cases dealing with racial segregation in public parks and universities in the light of Brown. Within a year, the court simply cited Brown to invalidate racial segregation in recreational facilities, and within 2 years in transportation itself. A decision is justified, Graglia points out, when it is based on a principle whose validity and applicability cannot be persuasively challenged. If one assumes that the issue in the Brown case was a proper one for the court to decide, and assumes that one should not be disadvantaged by government on the basis of its ancestry, admittedly a principle that is neither absolute nor the answer to all racial questions, but which may be as close to a useful absolute as any we have, then the Brown decision, Graglia feels, is justified by the point that there is no way that a trip of 10, 5, or even 2 miles can be made no more disadvantageous than a trip of only 1 mile. Graglia says, the appeal and general acceptance of a simple prohibition of all racial discrimination are so great, indeed, that it is hardly possible to quarrel with the Brown decision. Graglia points out the court did have uncited constitutional precedent in the 1890 case of Strada v. West Virginia for the Brown decision on the basis that the law was not the same for the black as for the white, as distinct from the opinion, except on the ground that so important a social change should not have been made by unelected lifetime appointees. The Brown case was a less traditional lawsuit than a call for a social revolution. In a healthy democracy, social revolutions are made by elected representatives authorized to effectuate their political views and accountable for the results. The fact that this revolution was made or greatly advanced by judges soon led to many other revolutions, much less justifiable, being made in the same way. In Brown, too, 1955, the court refused to grant relief even with regard to the individual black school children who were the nominal plaintiffs. Uncertain that its new law was contradicted the approval of already existing segregated schools or the establishment of segregated by each of the 26 states having any substantial racial differences among their populations that enacted the law, the court alleged it was enforcing would prevail its own shaky legality and the principled opposition mounted against it. The court's decision lost sight of the individual plaintiffs whose rights and legal theory provided the court's only warrant for making a decision. Acknowledging that at times individual interests must be subordinated to a group classification, Graglia feels that the court's refusal to grant plaintiffs individual relief in effect utilized the very classification by race began by condemning. To Graglia, the most charitable interpretation is that the court, evidencing a less than subtle notion that Negroes, unlike whites, possess rights as a race rather than as individuals, so that particular Negroes could be delayed the enjoyment of their alleged by the court constitutional rights if progress is being made in improving the legal status of Negroes generally. The court had determined to deal with the problem as involving the rights of the Negro race rather than the rights of individuals. Failure to require present compliance with Brown enormously complicated and confused the issue. Instead of a relatively straightforward requirement of assignment without regard to race, the requirement became the production of a desegregation plan. The acceptability of different plans was then to be litigated for more than a decade. Under cover of the resulting confusion and delay, the original prohibition of segregation was metamorphosed into a requirement of integration, a drastic change that was never openly admitted and thereby never had to be justified. That the Brown gamble of the court was successfully established by the Civil Rights Act of 1964, which adopted the prohibition as national legislative policy. No longer feeling that Brown atrocity would not be made to prevail, the court became arrogant and indignant at the recalcitrance and delay its 10 years of hesitance had done much to encourage. By the time Griffin v. County School Board of Prince Edward County was decided less than 2 months before passage of the act, the prohibition on racial discrimination announced in Brown had become a requirement for maintenance of a public school system in practice. Neither written words of the bill itself nor specific congressional intent could in debate have been made plainer than what was the clearly enunciated principle that prohibition of discrimination in federally assisted programs could not be used to require positive integration. The possibility that a requirement of racial discrimination to achieve integration or racial balance might somehow result from the act was the strongest argument of his opponents and was repeatedly and emphatically denied by his proponents. Congressman Seller and Senator Humphrey repeatedly assured under the most precise questioning that such a result was impossible, contention that was regarded as essential to his passage. In practice, however, every assurance written into the act and and reiterated by its sponsors and supporters that it could not be made the basis of requirement of integration proved to be worthless. The Act's provision that no rule, regulation, or order would become effective without presidential approval afforded no protection against the Office of Education or the federal court system. A clear illustration of administrative and judicial perversion of legislative purpose, states Graglia, would be difficult to find. By this time, the federal courts at all levels had become long accustomed to formulating and supervising methods of school assignment and to prying school boards to ever more vigorous efforts. The court's exertions had gained not only acceptance but endorsement and applause. The moral superiority of the judicial to the political process came to be widely recognized. Full compliance with Brown could not be achieved, but judicial withdrawal from control of the schools could no longer be expected. By means of wordplay and charlatanism, the constitutional mandate alleged in Brown was changed from a prohibition of racial integration to separate the races to a requirement of racial discrimination to mix them. With reasoning sufficiently illogical and obscure to divine explanation, the court defeated congressional pronouncement and turned the provisions of the act against itself. Administratively imposed requirements prohibited the Civil Rights Act of 1964 were raised by the courts to the level of a constitutional requirement. Congress would lose the power to eliminate it. Even by repealing the original legislation, there was the opponents of the act were proved correct in contending no way to combat recognized evil without bringing about a possibly greater one. The Supreme Court itself endorsed administrative misuse of the act for the purpose of requiring integration. Instead of providing a restraint on the excesses of other government officials, the traditional justification of the Supreme Court's extraordinary power, the court proved itself to be the most dangerous source of excess. The Supreme Court failed to justify compulsory integration for its own sake by claiming that integration is not required for its own sake, but only in order to remedy that segregation prohibited in Brown. Graglia shows how this claim became more obviously fictional with each succeeding case. The court's logical sophistry and semantic stratagem served to minimize national attention and concerning consequently opposition and to make the decision seem but another step taken by a patient court to counteract still another by the recalcitrant South to evade the requirement of Brown. Court requirements of busing to achieve integration are described by Graglia as a bizarre development. It was, he states, almost as if the weakening of public support for public schools and the increase of racial separation in schools and cities had become not only the inevitable concomitant of what the federal courts required, but in the blindness of understood tyranny, the objective. The decisions of the four justices appointed by a president who made opposition to busing a major part of his program for domestic peace and resulted in no infusion of responsibility into the court. Roosevelt did ultimately succeed in stopping the court's invalidation of the New Deal, but that was a conservative court seeking to impede basic social change. The court, since Brown, has become the nation's principal engine of change. The superiority of its policy-making over policy-making by elected representatives has therefore been so long and so loudly proclaimed by many of our most articulate and influential citizens that the power of the court is now much more difficult to overcome. The Supreme Court decision in Milliken v. Bradley, 1974, is said to provide a fitting conclusion to the unhappy story of the Supreme Court's decision on race and education since Brown. Here, desegregation could be required in a district shown never to have been segregated. Apparently, suburban districts of Detroit had violated the Constitution by building their own schools rather than sending their children to schools in Detroit. Graglia articulates on the cost of abandoning neighborhood schools and enter some caveats to this opposed benefits of compulsory integration in education. He suggests rather mildly, in this case, there appears to be a general and growing agreement that the claim of improved black academic performance as a result of compulsory integration is dubious, and that compulsory integration is not likely to be justified on the basis. Page 271. He also contends that compulsory integration is self-defeating of the court's own intention in the sense that compulsory integration often operates to create more rather than few majority black schools. Furthermore, the court's requirement of integration has introduced in the political process a gross distortion of traditional representative government.